Welcome to the Institution for Higher Learning and Common Law. It's January 24th, 2016. Tonight we're going to cover what land within the 50 states may the federal government own. Brad Parsons is going to be presenting this study. Brad, take it away.
Thank you, Joseph. First, let me preface this presentation with this statement. If you don't know your rights, you don't have any. Now, that's a true statement, and it is truly a sad state of affairs, considering that the only job of any government is to protect the rights of the people. The following is the second paragraph of the Declaration of Independence. I've put it all here for those of you who want to get it. I'm not going to read the whole thing. Quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government," that unquote. It goes on to talk about what a government or what a people can do if their government becomes oppressive. I'll drop down to the end of this paragraph. Quote, "But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient suffering of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is the history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let the facts submitted to a candid world." Unquote. It is worthy to note and call attention to points relevant in today's states of the Union. First, these people who have been created as equals have been endowed by their Creator with certain unalienable rights. The government didn't give us our rights, nor did the Constitution. They were given to all men freely by our Creator, and therefore they cannot be taken away by other men or by governments without due process of law. Further, that these are only some of the rights given by the Creator, and that all such rights are unalienable, meaning that they cannot be taken from us. The named rights are life, liberty, and the pursuit of happiness. These three rights alone mean that we can do what we want, when we want, how we want, so long as we do not infringe upon the rights of others in doing so. The next sentence begins with a blockbuster. Quote, "To secure these rights, governments are instituted among men." Close quote. To secure the rights of the people is the only purpose of any government. The second paragraph then goes on to speak of tyranny and abuses and usurpations of government, which at the time was the King of England. Do you see any of that today in our land? Do any of the current events ring a bell and seem vaguely familiar? It seems that the federal government has taken possession of more and more land within the 50 states of the Union, so this might be an opportune time to discuss the only method that can be used by the federal government, the United States, to obtain land that is situate within the 50 states of the Union. The Constitution of the United States was implemented to severely curtail the central power of the federal government, to hold it in check, so to speak. And it distinctly addresses the manner in which the federal government may acquire land, and it does so in a very explicit and clear manner. This instruction is found in Article 1, Section 8, Clause 17, which is provided here and which we will discuss. Quote, "Congress shall have the power to exercise exclusive legislative jurisdiction in all cases whatsoever over such district, not exceeding 10 miles square, as may, by secession of particular states and the acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, unquote. Let's take this apart so that we can fully understand what it says. The land must be ceded to the government by the legislature or legislatures of the states in which it lies. That takes a specific legislative act on the part of the state legislature. It cannot be a passive thing. Since most states have a bicameral assembly for a legislature, the bill must pass both of those houses and then be submitted to the governor for his or her signature. The governor may veto the bill, but then the houses have the opportunity to override that veto if they choose. 2. The land must be purchased from the states by the federal government. This presumes the exchange of money, but it could be purchased with other benefits. The point is that there must be consideration tendered on both sides. 3. Once the land has been ceded to the federal government and payment has been made and received, jurisdiction must be accepted by the federal government. We will see that such notice of acceptance must be in writing and sent to the governor of the states involved. I submit here 2 pieces of evidence in support of this premise. One, a case decided by the Supreme Court of the United States, and the other, a code section from Title 40 of the United States Code. The Supreme Court of the United States cites 40 U.S.C. Section 255, and that section has been repealed, but it was reenacted as Section 3112. Section 3112, Federal Jurisdiction. Quote, subsection A, exclusive jurisdiction not required. It is not required that the federal government obtain exclusive jurisdiction in the United States over land or an interest in land it acquires. B, acquisition and acceptance of jurisdiction. When the head of a department, agency, or independent establishment of the government, or other authorized officer of the department, agency, or independent establishment considers it desirable, that individual may accept or secure from the state in which the land or an interest in land that is under the immediate jurisdiction, custody, or control of the individual is situated, consent to, or secession of, any jurisdiction over the land or interest not previously obtained. The individual shall indicate acceptance of jurisdiction on behalf of the government by filing a notice of acceptance with the governor of the state or in another manner prescribed by laws of the state where the land is situated. C, presumption. It is conclusively presumed that jurisdiction has not been accepted until the government accepts jurisdiction over land as provided in this section. Close quote. Subsection C will be their undoing. As an aside, I sent a public information request to the governor and the secretary of the state of Texas, requesting a copy of all notices of acceptance presented by any representative of the United States for each parcel of land that is claimed to be owned by the United States within the borders of the state. They both responded that they didn't have any idea or any documents. I am now in the process of going to the legal library archives of the state to see if they have them. As a matter of law, in a criminal matter, the prosecution must establish jurisdiction before the case can be heard. In the case of Adams versus U.S., the Supreme Court of the United States reversed the rape conviction of 3 soldiers who had been convicted of raping a civilian woman on Camp Claiborne in Louisiana because of this very point. It is a short case, so it is reproduced here for your benefit. Adams versus the United States. Quote, the Circuit Court of Appeals for the Fifth Circuit has certified to us 2 questions of law pursuant to 239 of the Judicial Code, 28 U.S.C. 346. The certificate shows that the 3 defendants were soldiers and were convicted under 18 U.S.C. 451 in the Federal District Court for the Western District of Louisiana for the rape of a civilian woman. The alleged offense occurred within the confines of Camp Claiborne, Louisiana, a government military camp, on land to which the government had acquired title at the time of the crime. The ultimate question is whether the camp was, at the time of the crime, within the federal criminal jurisdiction. The Act of October 9, 1940, 40 U.S.C. 255, passed prior to the acquisition of the land on which Camp Claiborne is located, provided that the United States agencies and authorities may accept exclusive or partial jurisdiction over lands acquired by the United States by filing a notice with the governor of the state on which the land is located or by taking other similar appropriate action. The Act provides further, unless and until the United States has accepted jurisdiction over lands hereafter to be acquired as aforesaid, it shall be conclusively presumed that no such jurisdiction has been accepted. The government had not given notice of acceptance of jurisdiction at the time of the alleged offense. The question certified as follows. 1. Is the effect of the Act of October 9, 1940, above quoted, to provide that, as to lands within a state thereafter acquired by the United States, no jurisdiction exists in the United States to enforce the criminal laws embraced in the United States Code, Title 18, Chapter 11, and especially Section 457, relating to rape by virtue of Section 451, third, as amended June 11, 1940, unless and until a consent to accept jurisdiction over such lands is filed on behalf of the United States as provided in said Act. 2. Had the District Court of the Western District of Louisiana jurisdiction, on the facts above set out, to try and sentence the appellants for the offense of rape committed within the bounds of Camp Claiborne on May 10, 1942. Since the government had not given the notice required by the 1940 Act, it clearly did not have either exclusive or partial jurisdiction over the camp area. The only possible reason suggested as to why the 1940 Act is inapplicable is that it does not require the government to give notice of acceptance of concurrent jurisdiction. This suggestion rests on the assumption that the term partial jurisdiction, as used in the Act, does not include concurrent jurisdiction. The legislation followed our decision in James v. Dravo Contracting Company, 302 U.S. 134, 58 South Court 208. Mason Company v. Tax Commission, 302 U.S. 186, and Collins versus Yosemite Park Company, 304 U.S. 518. These cases arose from controversies concerning the relation of federal and state powers over government property and had pointed the way to practical adjustments. The bill resulted from a cooperative study by government officials and was aimed at giving broad discretion to the various agencies in order that they might obtain only the necessary jurisdiction. The Act created a definite method of acceptance of jurisdiction so that all persons could know whether the government had obtained no jurisdiction at all, or partial jurisdiction, or exclusive jurisdiction. Both the Judge Advocate General of the Army and the Solicitor of the Department of Agriculture have construed the 1940 Act as requiring that notice of acceptance be filed if the government is to obtain concurrent jurisdiction. The Department of Justice has abandoned the view of jurisdiction, which prompted the institution of this proceeding, and now advises us of its view that concurrent jurisdiction can be acquired only by the formal acceptance prescribed in the Act. Since the government had not accepted jurisdiction in the manner required by the Act, the federal court had no jurisdiction of this proceeding. In this view, it is immaterial that Louisiana statutes authorize the government to take jurisdiction, since at the critical time, the jurisdiction had not been taken. Our answer to certified question number 1 is yes, and to question number 2 is no. It is so ordered. Close quote. The sequence of events were thus. Louisiana ceded land to the United States for the purpose of building a fort. 2. The United States built the fort and manned it with soldiers. 3. The alleged rape took place on the land that had been ceded to the federal government. 4. After the date of the alleged rape, the United States presented its notice of acceptance to the governor of Louisiana. Because the alleged rape took place prior to the notice of acceptance being submitted by the United States, jurisdiction did not attach, and the conviction was overturned. With very few exceptions, federal law only applies on federally owned property for which notice of acceptance has been submitted to the governor. How often does the prosecution show this evidence in criminal matters tried in federal court? My guess would be never. The good news is that there is no statute of limitations where a question of jurisdiction is concerned. So a motion to vacate can be filed at any time. If you are concerned about the direction in which your country is headed, if you want to try to change it, if you're an oath keeper, or if you're a patriot, join us at Institution for Higher Learning in commonlaw.com. We welcome your ideas and your energy. We look forward to hearing from you. God bless you, and good night.